I'm John McDonald of 2 Temple Gardens. Thank you very much for joining this webinar, which is one of a series we're doing during the coronavirus lockdown. If you've just joined, please could you make sure your video and microphone are both off. This webinar isn't just for beginners, although you're all very welcome, but also for more experienced practitioners who've dealt with a number of motor insurance cases and want to fit them into an orderly framework of law. In the 25 minutes or so in which I'll be speaking, I'll try and outline how the English system works. I'll also point out some particular areas in which the law remains uncertain and where there may be litigation in the near future. And there may be some time for some questions at the end. The English motor insurance system has been described as a somewhat rickety house onto which various outbuildings and lean-tos have been added over the years. Add to that the effect of EU law, and add to the likely effect of Brexit, and the resulting structure looks as though it's unfit for habitation. But the one key principle of the system is to ensure that if an innocent person gets injured or suffers damage as a result of a road traffic accident, whether that person's a pedestrian, a passenger in a vehicle, or the driver of another vehicle, there is some body, and not just an impecunious defendant, who will meet his or her claim. Many of the complications in the UK, as opposed to the EU, for example, arise from the fact that in this country, motor insurers insure the driver and not the vehicle. That means that even in the case of an accident involving only one vehicle, a number of insurers may be involved. Added to that is the fact that under the English law of joint and several liability, a claimant may recover the whole of his damages against any one of 2 or more joint tortfeasors. This means, for example, that if one of those tortfeasors is insured and the other isn't, the victim can recover the whole of his damages against the tortfeasor and thus against that tortfeasor's insurer, leaving the insurer with a probably worthless remedy against the uninsured driver. The law is developed in such a way that a given motor insurer may have to meet a claim, even though there is a contractual exclusion in the policy, even if it has not insured the person driving the vehicle, or even if the vehicle is being used for a purpose not covered by the policy, for example, as a minicab rather than for social, domestic and pleasure purposes. Whether that insurer does in fact have to meet a claim, particularly when another insurer, motor or otherwise, is on the scene, depends on the insurer's position on what's come to be known as the liability tree. As the judge explained in Advantage and Stoodley, the contractual insurer sits at the top of the tree and the MIB central fund sits at the bottom. And what he said was this: as a general proposition, and looked at from the perspective of an insurer, if an insurer higher up the tree falls out, then liability to indemnify or satisfy judgment will rest with the insurer immediately below. And we come on then to what I hope you can see on the slide is the liability tree. It's come out fairly small, but at the top is the contractual insurer. He's the top of the tree. Since the 1930s, there's been a requirement in English law for drivers to have motor insurance. And this is now reflected in sections 143 and 145 of the Road Traffic Act. These provide that a person must not use a motor vehicle on a road or other public place unless there's in force in relation to that use a policy which insures him or her against liability for death or injury caused by or arising out of the use of that vehicle. And you can see it, I hope, on the slide now. Maybe not, I think it's the wrong slide. There we go. There are several things to point out about the requirements of sections 143 and 145. First of all, the obligations on the motorist to have insurance complying with these requirements, and not on an insurer to issue a policy complying with them. Second, most motor policies contain all sorts of exceptions and conditions which purport to limit the scope of cover under the policy. So these fall into 2 main categories. First of all, there are some exceptions which are expressly banned by section 148 of the Road Traffic Act. A good example of that is a policy term stating there'll be no cover if the driver uses the vehicle under the influence of alcohol. Another is that there will be no cover unless you report the accident within a set period after it's occurred. Now, you may well wonder why insurers bother to include these. The main purpose seems to be to enable the insurer under other contractual policy terms or under statute to recover its outlay from the policyholder. The other category of exclusions are interesting ones and ones on which there's some current debate, and they relate to matters such as deliberate damage or when the driver is engaged in racing with another motorist. These exclusions aren't expressly prohibited by the RTA, although there's continuing debate as to their interpretation. What is, quote, deliberate damage? What constitutes, quote, racing? There are only a few cases on these issues, although I appeared in a case called Pin and Guo in 2014, which is on Lawtel, where I managed to persuade the judge that my insured driver was, quote, racing within the meaning of our policy, with the result that some other insurer had to meet the claims. There's also a debate as to whether such exclusions are in fact permitted in English law at all, although for the present there is binding authority in Bristol Alliance and Williams to the effect that they are. So one area of uncertainty is whether this category of exclusions is permitted. The third thing to note about the definitions of caused by and arising out of is what is meant by using a motor vehicle, what is meant by, caused by, or arising out of such use. The matter was considered not terribly helpful, it must be said, in the recent Supreme Court decision in UK Insurance and Pilling. Now, in that case, it was held that Section 145 reflects the provisions of Article 3 of the EU Motor Insurance Directive. And so Section 145 must, in accordance with the Marleasing principle, be read so as to accord with European court decisions on use. But there remains uncertainty as to its interpretation, and further litigation on the point is likely. Next down the tree is the RTA insurer. Under Section 151 of the Road Traffic Act, a motor insurer is subject to certain conditions and exceptions under a duty to satisfy a judgment, even if it's not in fact insured the person driving. In particular, under Section 1512B, if the liability is one which would be covered if the policy insured all persons, and the judgment is obtained against someone who is not insured under the policy, then the insurer must still meet the claim. Take an example. If my wife alone is insured to drive her car for social, domestic and pleasure purposes, and I'm driving it for social, domestic and pleasure purposes, then her insurer must meet a claim against me, although it'll have a right of recovery from me and may have recovery of right against her as well. But if, for example, I'm driving her car as a minicab or for business use, the insurer will not be liable to meet the claim, at any rate as a Road Traffic Act insurer, because it's not a risk which will be covered if the policy covers all persons. One contentious area relating to this, where there could well be litigation in the future, is as to the effect of the sale of a vehicle. Suppose A takes out a motor policy on his car, which covers only him to drive it. He sells the car to B, but forgets to cancel the policy. B hasn't taken out his own policy in respect to the car and has an accident in it, in which some third party is injured. Does A's insurer have to meet that claim as RTA insurer? Well, on the face of it, the situation would appear to fall squarely within Section 151, in that the policy would have covered B if it had covered all persons. But what about the argument that A no longer has an insurable interest in the car? Is that sufficient to make the policy lapse on the sale from A to B? There's no authority on the point, and the textbook writers seem to be in two minds about it. I leave that one for you to think about. There used to be a provision in the RTA that if an insurer was entitled to avoid a motor policy for non-disclosure or misrepresentation, then it could get a declaration to that effect under Section 152, thereby enabling it to meet the claim at least under Section 151. Paradoxically, in view of our subsequent departure from the EU, regulations came into force on the 1st of November 2019, specifically to bring us into line with EU law, which have effectively abolished that provision, so that the brisk business in obtaining Section 152 declarations has now dried up. Come on to the next slide. Before we come down another branch on the liability tree, let's have a look at the position as between a contractual insurer and an RTA insurer. Suppose C, who's the claimant, is a passenger in a car driven by A. You may not be able to see it, but A is the yellow car on the left-hand side. So A's got a contractual insurer, and there's a collision between that car and one driven by B, for which there's only an RTA insurer. Suppose the drivers A and B are both at fault, so they're both jointly and severally liable to C for his injury. Does A's insurer have to meet the whole claim, or should it be shared between that insurer and the RTA insurer in respect of B? The context is this, of course, that a contractual insurer has to indemnify his insured against his liability to a third party. And of course, there's a direct right against the insurer under the 2002 regulations. Whereas the third party in an RTA insurer case, the RTA insurer's obligation is only to satisfy the judgment against the driver. It's required under Section 151(5) to pay to the persons entitled to the benefits of the judgment any sums payable under the judgment in respect to the liability. So when there's both a contractual and an RTA insurer in respect to the same claim, which of them must meet that claim? Although it's often been assumed that a contractual insurer trumps an RTA insurer and so must meet the whole claim, the answer is not in fact clear from the wording of the Road Traffic Act. My view, although the matter has not been the subject of any authoritative decision in the courts, is that it's implicit in cases such as Eagle Star and Provincial that the hierarchy is such that the contractual insurer would effectively have to meet the claim alone, because the RTA insurer would have a right of contribution, whether under the Act, under the law of restitution, or by way of equitable contribution between insurers from the contractual insurer. Coming down the next branch of the liability tree, we have the contractual insurer, the RTA insurer. We've next got the Article 75 insurer, perching on the next branch down. This is a reference to Article 75 of the MIB's Articles of Association. Now, in order to understand the position of such an insurer, you need to know a bit about the MIB. From 1946, the motor insurance industry has had a series of agreements with the government under which the industry, through the MIB, undertake to satisfy unsatisfied judgments in respect of RTAs. If there's a contractual or RTA insurer which can meet the claim, then the judgment is not usually unsatisfied. But if there is no such insurer, then if the judgment is unsatisfied within 7 days, MIB has to meet the claim. All insurers who write motor business have to be members of MIB, and its Articles of Association constitute a contract between those members. So an Article 75 insurer has to satisfy an unsatisfied judgment, but only subject to the conditions and exceptions contained in the MIB Uninsured Drivers Agreement, which we'll come to look at shortly. What does an Article 75 insurer mean? Well, by Article 75(2)(a) of the MIB Articles of Association, Article 75 insurer is defined as the member who, for the time of the event which gave rise to a Road Traffic Act liability, was providing any insurance other than by reason only of a driving other vehicles clause in respect of the vehicle from the use of which the liability of the judgment debtor arose. So an insurer is an Article 75 insurer, even if, for example, the use of the vehicle was other than that covered by the policy. So, for example, if someone, X we'll call them, has a policy covering social, domestic and pleasure use only, but drives the vehicle as a minicab, his insurer will be liable as Article 75 insurer, and so has to meet the claim, subject, of course, to a right of recovery against X, unless there's another insurer in the frame as well. Other examples of Article 75 insurer would be where there was an effective exclusion in the policy, for example, in relation to deliberate damage or racing. The main battleground between motor insurers, at least so far as court proceedings are concerned, is whether one or both of them is only Article 75 insurer rather than contractual or RTA insurer. This may arise in a number of ways, but in the example I mentioned before, and you can see it on the slide, suppose C, the claimant's a passenger in a car driven by A, who has a contractual or RTA insurer, which is in collision with a car driven by B, for which is only an Article 75 insurer. A and B are jointly and severally liable to C for his injury. B's insurer only has to satisfy an unsatisfied judgment, so that because A's insurer will either meet the claim as contractual insurer or will satisfy it as RTA insurer, B's insurer gets off the hook. Back to the tree again. If one insurer is undoubtedly Article 75 insurer, or if the issue is, for example, whether it's a contractual or Article 75 insurer, then the fight between it and other insurers will generally be one for the courts. But issues often arise as to whether an insurer is an Article 75 insurer at all. In that case, the matter is determined by the MIB Technical Committee. This is a body consisting of representatives of member insurers, which meet several times a year in order to determine issues such as whether a given insurer is an Article 75 insurer. It's important to bear in mind, A, that the proceedings of the Tech Committee don't generally involve lawyers, although you may well be asked to advise insurers on how to present their claim for the committee. B, there's now a complex procedure under which the dispute can be dealt with by arbitration instead. And C, there's a right of appeal from the decision of the Tech Committee. Before moving down another branch on the liability tree, could I mention two areas of potential current controversy relating to Article 75 status? The first arises out of the recent Court of Appeal case of MIB and Lewis. Now, as we've seen by sections 143 and 145 of the RTA, insurance in the UK is only compulsory where the damage is caused by or arises out of the use of the motor vehicle on a road or other public place. But under EU law, there's no such restriction, and member states are required to ensure that civil liability in respect of the use of vehicles, whether on public or private land, is covered by insurance. In MIB and Lewis, it was held that as an emanation of the state, that EU concept, MIB must meet all uninsured claims, whether the use is on a road or other public place or not. So what's the position of an Article 75 insurer? If the accident results from use on private land, does it have to meet the claim? This matter hasn't been determined by the courts, nor, so far as I'm aware, by the MIB Technical Committee. But in my view, and I think that of many other practitioners in the field, my view is that an Article 75 insurer would not itself have to meet such a claim. And that's because the liability would not be a, quote, Road Traffic Act liability, as defined under the articles. But you've got to remember that MIB revises its Articles of Association usually each year. And by Article 75(1)(b), it's the current version of those articles which applies whenever the accident occurs. So MIB may well amend the definition of Article 75 insurer to cover such off-road accidents. The second point on Article 75 is this. These days, many motor policies are taken out online, and it's not uncommon for people to pretend that they're someone else when applying online, usually someone older or with a better driving record, so as to get cheaper or indeed any insurance. In a case called Shogun Finance and Hudson back in 2004, the House of Lords held by a majority, albeit in a different context, that where a contract's in writing as opposed to oral, only the persons named in the writing can be parties to the contract, and that if the purported contracting party named in the writing knew nothing of the agreement, no binding contract is formed. In such a case, is the insurer an Article 75 insurer and so liable to meet a claim? Once again, there's no court decision on the point, and the matter would primarily be one for the MIB Tech Committee to determine. My view is it would be likely to hold that because the insurance had been obtained by mistake, which is included in the definition of Article 75 insurer, the insurer would be an Article 75 insurer and so have to meet the claim, but the matter is not certain. Next branch down on the tree is the MIB itself, and it may have to meet a claim in one of two ways. First of all, if there's no contractual RTA or Article 75 insurer, then the MIB has to meet the claim. In other words, in effect, it shares the claim with all the motor insurers in the country. Such claims are governed by the current, which is the 2015 MIB Uninsured Drivers Agreement, which you can find on the MIB website. I won't go into detail on this agreement, but it's relevant to note that it contains a number of important conditions and exceptions. I mentioned just two. First of all, MIB doesn't have to meet a claim if the victim has another source of recovery, for example, under his own rather than the tortfeasor's insurance. So to take an example, if you have a comprehensive policy and your car is damaged by the fault of an uninsured driver of another vehicle, you can't rely on the 2015 agreement so as to get compensation from the MIB. Second example, on which there's quite a bit of litigation, is this: a victim who is a passenger in the vehicle in question, where it's being driven by an uninsured driver, can't recover from the MIB if he, quotes, knew or had reason to believe that the vehicle had been stolen or unlawfully taken, or that the driver was uninsured. And as I say, there are quite a lot of cases on what knew or had reason to believe might mean. Next down the tree comes the MIB Untraced Drivers Agreement, which applies in the case of an accident where the at-fault driver can't be identified. It's called untraced, but the criterion is whether the driver can or cannot be identified. In such a situation, the application is made to the MIB, and it deals with the questions of liability and quantum itself, subject to a right of appeal to an arbitrator, including an oral hearing if the matter can't be resolved otherwise. It's important to note that the costs which a claimant may recover from MIB under the untraced agreement are very limited, the reason being that MIB itself carries out the investigation into the accident. In Cameron and LV Insurance last year, the claimant was injured when her car was involved in a hit-and-run accident. Someone got the registration number, so the car could be identified, but the at-fault driver couldn't. And the claimant's solicitors, anxious no doubt not to be restricted by the untraced agreement as to the amount of costs they could recover, brought a claim in court proceedings against, quote, the person unknown driving the car, with the insurers of the car, LV, as second defendant as RTA insurer. Well, the Supreme Court held that the claim against a person unknown was not permitted in this context, and that LV was not directly liable under EU law to meet such a claim. Hanging on the bottom branch of the liability tree is a Monk and Warby claim. Under section 143(1)(b) of the RTA, a person must not cause or permit any other person to use a motor vehicle on a road or other public place unless there is a policy of insurance in force covering that use. So it was held by the Court of Appeal in that case, if you cause or permit someone else to do so, an injured person can bring a claim against you for breach of statutory duty under that section. This cause of action was concocted in the days before the MIB existed, so that it provided a useful alternative claim against someone who might have the money to pay the damages, even if the driver didn't. Such a claim can, however, still be brought, as illustrated by the recent Court of Appeal case of Sahin and Havard. In that case, the claimant contended that under section 145 of the Act, motor insurance had to cover a Monk and Warby liability, so that if a person who caused or permitted the uninsured driving of a car by someone else herself had insurance, that insurer must meet the claim. It should be noted the Court of Appeal held against the claimant. We're running a bit late, I'm afraid, and so I've run out of time, luckily, before I have to deal with the mind-bending provisions of the EU Withdrawal Act 2018 and the EU Withdrawal Agreement Act 2020. Suffice it to say that under the transitional arrangements, which are in force until at least the end of this year, EU law will continue to have the same influence on English law as it's had up to now. So thank you very much for attending this webinar. I'll try and do a text of my talk, which will be available online if you want to have a copy as a short summary of this area of the law. You can contact me by email or otherwise, jmcdonald@2tg.co.uk, and the details are on our website. And please look out for forthcoming seminars which we're doing, which will include topics such as clinical negligence and stress at work. We're running a bit late, so I'm afraid there really aren't any time for questions, but please, if you want to get in contact through the website or through Chambers or directly with me by email, please do so. Keep safe and goodbye for now. Thank you.